Gentlemen, welcome to Pacific Waves TV USA. Today we discuss a very important legal topic that affects families, businesses, and future generations. And today we are discussing about succession and estate planning. Our guest is Advocate Steve Mbugua, who is our resident uh, advocate. In Kenya, we call them lawyers, but I think globally is the one and the same word. And he will help us understand how to protect our assets and ensure a smooth transfer of wealth to our loved ones. Wakili Mbugua, you can say hi to our viewers and
Thank
listeners
you very much.
today.
Thank you very much, Carrie, and I'm so happy to be here today once again. I want to salute every Kenyan living in diaspora, wherever you are, and listening to us. It's always a pleasure to be here to share, interact. My name is Wakili Steve Mbugua. I'm an advocate based in Kenya in a law firm that specializes majorly on matters to do with or helping our clients navigate through problems by providing precise legal solutions or strategic results.
Yeah, Wakili, how has been your week?
It has been great and just a few challenges here and there in terms of we are anticipating there will be some protests, especially in commemoration of what is the 2024 Gen Z protests. So that is a major political tension, and also the finance bill, which was being tabled before the assembly this week, which Kenyans were hoping for the best, but unfortunately, once again, our National Assembly uh, seems not to have pleased a section of Kenyans, and another section was not happy with it.
Oh, okay. The protest is on 25th?
Yes, the commemoration of the protest, the killings that happened in 2024 June are going to be done on June 25th this year, based on the notice that was issued by the human rights-based organizations that they're going to commemorate it through protest. So it's just a way of coming together and remembering the killings that we witnessed, and a call for justice for the persons and all the families that lost their loved ones during the protest.
We hope all shall be well.
Indeed, we are hoping all shall be well, and it's our prayer also with the family that lost their loved ones that they find peace and comfort in the Lord.
It shall be well, and it has to be well.
Yes, indeed, it has to, because it's our duty to always push for a better Kenya, and for people to live in a better country that respects the rule of law, and also a country that respects the constitution. So it's our clamor that things are going to be better. Institutions are going to respect the law, and also people are going to feel protected by the law.
Yeah, and that's why, Wakili, I want you to address to Kenyans living in diaspora. And
Mm,
that's why I requested you today we discuss about understanding succession and estate planning.
mm.
And my first question will I'll ask you, what is succession and why is it important for every family?
Uh, Gary, one thing I would like to say as I start this conversation is that many people, when they hear this conversation of succession or the estate planning, the assumption is always we are discussing about death, we are discussing about you not being here, but it's mainly about a process of ensuring you manage your estate and your legacy in a better way, in a structured way, for the benefit of your loved one. So when we say the word succession itself is used to explain or indicate the process in which property moves from the deceased to the intended beneficiary. So, whenever someone has passed on and they have a legacy, they have properties, they have estate, then that estate can only be managed if it is passed through a process called probate, and that is done through our court system. So that is very important why we're having this conversation today to discuss about estate planning, because if you don't plan yourself well, then you may find the law planning it for you. And the law is not really fair in terms of your wishes or what you like to do with your property when you're not around.
What is difference between a succession planning and estate planning?
They both mean the same thing, because estate, when you say estate or when you're telling someone, is an as in you have an estate. You know, most of the time people wonder or assume the word succession planning or estate planning. It is a terms used for people who are rich, people who are very wealthy, but these are just meant to ensure that that small plot you have, that investment you have made in a company like shares, those businesses you have established, those properties don't get lost in the process when you're not around. When something unfortunate happens to you, then those properties should not be lost. But instead, there should be a smoother way, an easier way that should transfer those properties and the benefits to your children and your loved ones. Because it is so sad when you see families which their parents accumulated a lot of wealth, bought a lot of properties, there's a huge legacy in their estate. But unfortunately, once the parents they live chaos. People even start killing each other. You find property is destroyed in the process and lost. And even families are broken forever. And all this is because someone or a parent just to plan their estate or plans to their succession. So we always advise our clients that it's important you plan your future, you plan a future when you will not be there, a time when you will not be there, how your children will enjoy this benefit. It is so sad when you can see children being kicked out of school because their parents have a lot of money in their accounts, but they can't access the money in the bank because just someone failed to prepare or to plan their estate. So estate planning is just a better way of ensuring that you, when you leave behind, when your legacy, the legacy you leave behind is not wasted, but instead it benefits those who are intended to benefit, like your children and your loved ones. Because you can't lose all that investment after working all that hard. It will be so unfortunate for it to be lost.
Why do many families encounter conflicts after the death of a loved one?
I think, Kerry, as I mentioned, the major reason of conflict is something we call uncertainty. People, whenever people have anxiety, people can't be able to predict the results. They tend to fall into conflict because nobody knows who is supposed to benefit on this property. Mom left us a land in 1 acre of land in Juja. They left another property, an apartment in Nakuru town. There's another house in Mombasa. So who is supposed to pick which property? Who is supposed to share which proceeds? Is it my brothers, my sisters? Is it my children? That lack of certainty is in the family, is what brings conflict, is what has put families in court for years. You find a family was very rich, very renowned family, they had wealth, their father had wealth, but upon the demise of such a parent, once that father has died, once such parent has died, that family gets into a spiral of chaos and wars. And it has happened. We see it in our courts every day. And I always tell my client, it's very expensive to manage court processes when it comes to cases in courts. It's always easier to avoid those processes in court by planning your things early. And planning them is having a will, ensuring that you have a will, putting up family trust for your children, putting up systems and securities for your children in a way that estate will transition easily and without a lot of expense for them to enjoy and to avoid chaos. Even families and brothers and sisters fighting, because we have seen families fight. Sometimes scary, you will see a second family has popped up during a burial and they now demand they want a benefit of, they want a share from the estate. These are people you never knew in their existence. Then they have popped up. there's another child who has popped up, you never knew about their existence. That child also may also be coming in to also try and pursue their inheritance because they belong to that family. Whether now that is a question of proving whether they belong to that family. But in essence, such a family may fall into a spiral of chaos just because a parent failed to plan their estate. Just after working so hard, after acquiring all these properties, they failed to plan how these properties would go. Even if you have that child, we always tell families it's important to have mechanisms of ensuring you provide for them. You provide for them through your will, you provide for them through the trust, and those are things that you can only do when you are alive, you can only do when you are healthy, and when things are okay. Because when you are not there, the law will take its course. And the law, as I told you, is not really fair on the wishes of what you belong to do. So, for your wishes to be implemented, plan it early. And it is never too early to plan for the time that you'll not be around. Because we never know when you're not going to be there.
Okay, Wakili, you have said
Yes.
when is light time. Uh, Tell us what are the common misconceptions people have about the will, and tell us at what stage should I, should the owner of the should somebody start estate planning? At what stage, and what are the misconceptions,
Okay,
especially
okay.
Kenyans have about the will?
Yes.
Because one of the misconceptions you mentioned is when you mention will, people think about death. What other
Yes, yes.
misconceptions do people have, and at what stage
Mm.
should estate planning start?
Kerry, I'd like our viewers to understand that estate planning should start the moment you have realized you have established your estate. And most of the time, people wonder what estate entails. It doesn't entail those big tracts of lands or all those big, huge estates you're imagining. The moment you have those shares, whether they are worth 100,000 shillings, whether they are worth how much, that is estate enough because those are things that you need to have a way of handing them over for your loved ones and you're not going to be there. And therefore, to ask ourselves or to answer the question, when is the best time to plan your estate? The best time is now. When you have that, when you have realized you have that title, you have that title with you, you have that property with you, start planning it now. The earlier, the better. A will can be amended anytime, any day. When you buy another land tomorrow, you can amend your will. When you change or you get more children, you can always amend it. But it is safer and better when you have written it early than when you wait for it in the future, hoping that maybe that is something you'll do when you're older enough, probably when you acquire more wealth. But you can't wait for all that because we don't know about tomorrow. We never know about tomorrow, Carrie. So for that, we always advise our clients, plan your estate early by ensuring write your will early. Also, remember when you're writing your will, it is also important to ensure that the will conforms with the legal requirement because you can make the mistake of writing a will by way of trying to plan your estate. But unfortunately, you find the same will has been invalidated by the law because when it was taken to court, it was found to be one leaving out children. Some of your children have been left out because maybe you were angry with the child. It is important, our viewers, to always know that when you're writing your wills, you should not leave out the intended beneficiaries. You should always ensure that they are all provided for because failure to provide for any beneficiary who is rightfully supposed to be provided for, especially the children and the spouses, will always lead to invalidation of that will. And essentially, that would mean again the estate will be distributed through something in law we call intestate. And you see, when it intestate, that means that it is the court which is going to decide in its own discretion how they're going to distribute, whom they're going to give what. Probably that is not how, as a parent, you had planned to distribute your wealth to your children. Maybe there is a mechanism or there's a way you wanted to give it out, but when you're not there and you didn't have planned about it in advance, then unfortunately you face that problem. So to avoid that chaos and that uncertainty to our children and our future generation and our loved ones whom we have been working so hard for, then we start planning now. We start planning it now. You reach out to the lawyer, you engage, you prepare that will, just have it. You can always amend next year if you buy a new property. When you sell another one, you will amend until the time when the Lord will take you out of this world. Because it is certain, Gary, that we are going to all leave this world. We all don't know when. So to avoid that problem for our loved ones, we plan our future and we plan for a time we will not be there.
That brings us to my next question. Who is legally eligible to write a will?
Gary, anybody who is above the age of 18 and is of sound mind is capable and eligible to write a will. And the purpose of the will is to hand over what you have. Whether you have a bicycle, you have a car, you have land, you have money in the banks, and the purpose that will is an instrument or a legal instrument that is used to pass over that estate to your loved ones. And it also gives you the discretion because, as I told you, where there is no will, the court majorly lies, or apart from where family may have consensus, the court will just rely on the law. And the law may be harsh to your wishes. But when you have a will, it is a chance for a person to make their own discretion on how they're going to give their land. I have 10 acres of land. I'll give my first child 3 acres. I'll give my daughter 4 acres on this side. I'll give another child maybe another else to be equivalent of what maybe I've distributed to the other people. So you have the discretion. Even if you want to give a third party, you want to give a cow to your neighbor, there's a plot you want to give to a child of your brother. It is only through the will that you can do that, because any other way, if there is no will, then those people who are not in the list of the persons who are beneficiaries according to the law, that is children, spouses, or parents, may not really benefit. So that family friend or that child you adopted, that village child you have been supporting, probably if you want to provide for them, then through a will, that's the only secure way. That child of yours who maybe nobody knows about, if you have not planned for them, planning through a trust is another way that can help you as a parent to ensure that you provide for them. So it's very important to understand that wills should be done as early as possible, but as you do them, you must ensure that a person is of sound mind, an adult, and secondly, have at least 2 wills, and this is benefiting anything of that. Because if they are, then that will be invalidated if it is challenged in a court of law. So let's be very careful, and let's ensure we consult before we engage, so that you come very easy and so that your wishes are always secure as a client.
Okay, Wakili, I hope your internet is strong enough, because there are some words we didn't hear. But I have a question. What are
Yes.
the legal requirements for a valid will in Kenya?
The will to be regarded as valid, as I told you, the person who is doing it must be an adult and of sound mind. So sometimes you find parents have been forced to write a will when they are senile at the old age, or when maybe they are not mentally stable or okay. So such wills are challenged in court and invalidated. So the best, the will can only be done if someone is of mentally stable mind. And secondly, or thirdly, you must have witnesses. So if you don't have these 2 independent witnesses, and we always encourage clients to get a younger person, a younger person. Why? Because these witnesses are going to be your witness when you're not going to be there. They're going to witness this will. They don't have to necessarily know what is in the will. They don't have to know. All they need to know is that this is your will and this is your signature on the will. So they are only witnessing the signature. they don't witness the content. And that helps or ensures that confidentiality of what you have listed, and they're not going to know what you have distributed unless you want them to know. So essentially, the presence of two independent witnesses does not interfere with your confidentiality when it comes to matters of the will. But as I said, it's always best to do it when you're young, when you feel you're ready, when everything looks okay, because that other time you'll think that is the time you need it. It will be too late. That is the time that you find parents are sick, they're in the hospital, they're bedridden. Those wills they write there are challenged in court, and again they are cancelled because maybe at the time they are found not to be mentally okay, or they were being given drugs which were not giving them sound mental space to be able to write a will. So it's very important we plan early and we do it when everything seems to be very right.
What are the circumstances that can cause a will to be charged in court?
Sometimes you find some children carrying are also mischievous. They will notice that the parent is old, the other siblings have left, maybe they're out of the country. So they are the ones who are taking care of the parents. So they keep them around, they want to pamper them at that old age. And they take advantage of that vulnerability to coerce parents to write a will. And those kind of coercions or intimidation, sometimes even they are threatened. Some parents are even beaten now to write wills by children. So if there are such instances and they are able to be proved, then that will is cancelled and the law will not even negotiate any further. So it is important people to understand that will must be done voluntarily when someone is very much sober in their right mind. And that's why we encourage our clients to ensure they consult legal services from a professional before they engage, because those mistakes are done home and people right find themselves in a mechanism of ensuring that the will is valid and not challenged in the future. So that is something that our clients should always take home.
You said somebody can look for younger witnesses, and you said that
Yeah.
a witness will just write a signature without knowing the content. How can you be a witness of something you don't know the content? What are
In
you
the,
going to witness? What, in case you are called to testify, what are you going to testify? Because you just wrote a signature and of a content you didn't know.
Now, that is something I want our viewers to know, that the law have made it very clear that when you are looking for witnesses, find independent witnesses. And these independent witnesses have also been directed that they are only witnessing the signature of the person who is making the testator, the person who is making the will. The person, so if they are witnessing my will, they don't need to know what the 10 pages of the will talks about. All they need to know is me as Steve confirming to you, Mr. Kiari, as my witness, that document is my will. And down here, this is my signature. So I would like you to witness this signature for me, not the content of the will. So unless you just want them to know what you have distributed and how, there is nowhere you're obligated to tell them. And I think that is where you find essentially the law doesn't want any, even when you're looking for these independent witnesses, they're not there to say that, hey, Kerry, you give this person 5 acres of land, this person you give them. No, their presence, even in a court of law when such will is being challenged, is not to confirm how the estate was distributed. Their presence is to confirm that Wakili Steve wrote this will and this is his signature. Just that.
Okay. Is there any difference between a written will and oral will?
Mm.
And is oral will legal?
Yes, thank you. That is a question we always receive many a times from our clients. And we always want to remind our client that what is documented can never be challenged. So written will are always the safest mode of wheeling out your rights. and planning your estate because they're the most secure way. However, there is the aspect of auto will, which I would like our viewers to understand. That auto will only applies to a particular section of people. That is the military people, those merchants who go in the high seas. Those are the kind of people who benefit from the auto will for a longer period more than 3 months. Because according to the law, if you give an auto will, if today you're distributing your estate that I want to give out this land to this person, this one should happen when I die, then the law then anticipate that such person must die within 3 months. So if you don't die within 3 months, then that will is invalidated and is no longer in existence. So whenever you hear people saying that hey, mzee alikuwa amesema mwaka mmoja before he died, how the property will be distributed, those 1 year ago before the death are just wishes because it is only regarded as will if it is done within 3 months before the death, and it must be done in the presence of two independent witnesses. So even Mzee, as he distributes the estate orally, he must have two independent witnesses. So to avoid those challenges and to always know that the insecurity that comes with the auto will, because the auto will also is prone to distortion. Nobody is very secure on what kind of information will be passed over to the next person. So it's always best to have it documented, because once it is written, it can be rubbed unless you swear and attest another will, which we now the other will.
Okay, Wakili, how should a will be
Yes.
stored so that it will be accessible when it is needed? Where should
I think
it be stored or how?
one of the things we always encourage our clients is one, as I told you, to have a younger person. Why these younger people? They are also very critical. The assumption is not essentially at 100%, but the assumption is we will die old. An older person has a higher chance of dying than a younger person. So the younger person will be able to tell what exactly they saw and where they went, maybe and draw the will. But number two, it's also very important to always have a copy of the will with yourself or with your lawyers. Family definitely in your case.
Wakili, there's a problem with your internet.
Yes,
There was a
yes.
problem
I
with your
know that.
internet.
Yes, just a small bit. Yes, yes. Sorry about that. I'm saying
Okay.
you find that such will can also be stored as a document in your with your bank, so it can only be put in a secure place. The essence is to have it because for as long as somebody knows there is an existence of a will, upon the death, that will must be looked for. So as long as people know Mzee had written will, Mom had written a will, so that will be looked for and must be found either from their lawyers or from the bank's safes or wherever you store documents, either with the storage documents, organizations or companies. So it's essentially not a question of just carrying the document itself and say where do I put the will. Do people know, or do our people know, do our loved ones know that we had prepared our estate just in case something happened? Just in case something happened, kindly call XYZ law firm, call Wakili Steve law firm, they will assist you. Probably that's where you left your deposited your will. So it is a question of ensuring you have a trusted way of passing your estate to your children, your loved one, in a secure way, in a certain way, to avoid conflict and chaos. Because, as I told you, I've attended many burials where we have stopped, and I was not attending because I was invited for the burial or I knew the dead and deceased. But we find a client needed orders to stop such burials, or there's another person who is stopping burials. So you're also proceeding there to serve other orders. And you could look at even such a burial and the aftermath of such a burial, chaos befalling a family because of lack of planning. Lack of estate planning can bring chaos even at the date of the burial.
what happens in case a beneficiary is omitted in the will? Maybe
As I
I
mentioned to
did it
you,
like, maybe I didn't like that child, that or that beneficiary, or I have my clouds. The person drafting the will has some clouds
mm,
to omit a beneficiary. What happens?
yes. We like always reminding our client, and I would like to remind our viewers here, that when you're preparing the will, it is always important to have it conform with the law. Because the purpose of doing the will is to ensure that you successfully transfer the estate to your beloved ones without uncertainty. So one thing you should never do, no matter how angry you're feeling, no matter how offended you're feeling, is to omit a child or to omit a spouse from the list of beneficiaries. Because children, biological children or adopted children or stepchildren whom you have been adopted as your children, and your spouse cannot be omitted from that particular list when it comes to succession and list of beneficiaries, because they are given priority. Anybody else who comes to claim the part of the estate, the law burdens them to prove or to provide something we call dependency, to prove dependency. Show us how you were benefiting or how this person was assisting you. If you were paying your school fees, kindly bring the transcript, show us the benefit, and you'll only get the support to that extent. But for children, if you leave any of them out, then that will be invalidated. It will be set aside, and again, the estate will be distributed without a will. So it will be regarded as if it never had a will. So it's important to always remember, for that wealth you have worked hard for it to be securely passed on, don't leave any of your children out. The beauty about the will, it gives you a discretion. It does not talk about it does not give the limitation when it comes to how much can you give. It does not give a limitation. Carry, you can be having 10 acres of land. You can give one child 50 by 100 plot, and another child you can give them 8 acres. And the law will not interfere with that. The law will not listen to that child who goes to court to say that my father did not leave me or left me a smaller plot of land than my brother or my sister. But it will interfere with the will if you leave out beneficiary who is intended to benefit from that estate. Those are children and spouses. So it's important we don't leave them out, no matter how angry we're feeling. Sometimes I know feelings change. People have arguments, but we always remind them, don't leave them out if you want your wishes and your plans for your estate to be successful.
One of our listeners have asked a question, and I'll ask you, but you can choose not to answer because it may sound spiritual and not secular or legal.
Mm.
That a child, some children may fear challenging the will of their dad or their parent
Mm.
because they fear curse. They fear they might be cast.
Yeah.
What do you have to say? Uh, would you like to say something about that, or we go to our next topic?
Uh, I don't really want to focus on the issue of a spiritual aspect of classes or not, but what I can only request our viewer is that if the will does not conform with the law, if the will has left out a beneficiary, if the will was witnessed by probably one of the siblings who is also benefiting from that estate, if that will was written through coercion, then you have a right to challenge it. Doesn't matter what words were said, you have a right to challenge it if it falls within those particular elements of the law. But it is not that, then it is about how much you were given. I was given a smaller plot than the other. I was given which land or this which investment. Then that the court will not listen to you. And that is why we always advise our clients, plan early, avoid these kind of problems. Planning
Okay.
early is the best. Planning early.
Okay, thank you, thank you. Wakili, what is probate?
Probate means one and the same thing as what we have been talking about succession, but it's now managing or transitioning or managing a state using those instruments of the law we have been discussing about in terms of whether it's the law, tested, or using a will. And now, in probate administration, your will or your wishes, what you expressed, how you say the executor have appointed. You know, the beauty about planning this thing, Kerry, is that you find, and we like encouraging our viewers to always understanding, you get a discretion to even appoint a person who is going to help manage your children. You may even know that maybe might have these weaknesses, some have this problem, maybe my son may not be able to manage this land very well. You have a discretion to appoint an executor and get maybe a father figure in the village or in your family member, and you appoint them. Hey, come and join. You're going to be my executor, and I've appointed you. Your work is going to administer the estate and help my children settle down when it comes to or get their properties and everybody get their rightful share. So it gives you a lot of discretion, and that is what probate is about: moving that estate from the deceased hand to the hands of the intended beneficiary. Because if someone is selling the land of their father who passed on and the succession in the property has not been done, if someone is taking money from rent and misusing it and using it for their personal use, and they are not accounting to the estate, and they are not the administrator of the estate, they are not the executor of the estate, those persons are liable for criminal offenses called intermeddling. And persons like that in family, because you find there are people in the family carrying, will take advantage that my brother is not around, he traveled away, he has been schooling, he has been working out of the country, and I want to, I'm the one who is running the homestead. So you are misusing the properties, you are selling them. It's always important our viewers to know, especially those who are in diaspora, that you have a right to challenge those kind of activities because the estate can only be used and utilized after administration, good succession, and probate process.
Okay, is there anything called wealth preservation? I don't know how to put that question. Estate planning and wealth preservation.
Yes, I think it means one and the same thing because the purpose, carry the Bible reminds us for those who believe in Christianity that the best thing a parent can do is to leave a legacy for their children. So that legacy, if you left your children 100 acres of land in Nanyuki with maybe 1,000 cattle on it, and then after 5 years, those children have misused the property because you did not, they have been fighting, there have been chaos in management, and ultimately you find they have sold the land, all the animals have been slaughtered, or maybe they were mismanaged, then all the wealth is lost. So to preserve that wealth and to grow it more, that is where the aspect of estate planning comes in. That it helps you ensure that those cows, that farm, that business, those investments do not get lost or do not die when someone is not there if a bad thing happens. But instead, they move to the next person who you intended for them to benefit, whether it's your children, your family members, and they enjoy and grow it better. There are trusts which you can set up for children. You can set up for your family members, and they can benefit from them. So the aspect of estate plan is essential for preservation and growth of wealth for everyone who is caring about the future of their loved ones.
Okay, Wakili, like now you are in Kenya.
Yes.
Okay, we have some Kenyans that are working so hard in diaspora. Some are working here in America, others are in Canada, European
Mm.
countries, even Gulf, and
Yes.
especially here in America. People are investing
Mm.
here and also investing in Kenya.
Yes.
Why should re- late drafting a will important to them?
Hmm.
And
I think. Okay.
and if a will is written, okay, how can I write a will that we will cover all my properties here in diaspora and back in Kenya?
Kerry, I will say this: many people, and the major mistake most people do or make is to assume that family members know their wishes. Family members, their properties list. Family members know how they want their property to be distributed in case they are never there. But that is an assumption and a very dangerous assumption that most people make. So to avoid that problem, it is important to always ensure that you engage because you may have properties in Kenya and others in other countries, whether it's in US, Europe, or Saudis, or wherever you are outside Kenya. The most important, every country has different regimes of the law. But the most important and focusing majorly for me about Kenya is to ensure that those inventories, you keep them. Those inventories, you have them of all your properties. Then you have a plan through your will how that property will move from one the person from your hands to the person you intend or you care about. Because that assumption that our family members know what we intend or they know what we want, how our children should be managed. Maybe when I'm not there, you should pay school fees for my children in this manner. Those assumptions should be put to rest by planning and writing that, codifying those wishes in a will. So Kenyans living abroad, whether in Europe, whether in the Arabian world, whether in America, we encourage them to always get in touch, to always ensure that they have a will. If you have not written a will, write it now. If you had written it, review it now. It is time to have a review. So it's important to always have a check of keeping your inventory up to date because we never know about tomorrow, Kerry. And that uncertainty of tomorrow is what brings chaos because, as I told you, conflict thrive because of uncertainty. If people know what happened next, they know that this is what dad wished. They wanted that I go to this school or I access my school fees through these mechanisms. They wanted this property to go to this person. Nobody's going to fight. Nobody's going to fight. Everybody's going to live happy and grow, become better. So to avoid uncertainty, we plan early and we plan right.
What happens if a person dies without a will? And what challenges does it bring to the family members or the beneficiaries?
Uh, the unfortunate part about dying without a will is that the law distributes the estate. And the law is not going to be fair in terms of wishes, but it will be fair in terms of what it deems just. So that means that if there was an estate or you had some land, you had some proper some plot somewhere you had bought, you had some investments through shares, stocks, and all that, and you wanted to hand over to your children. In the will, as I mentioned, you have a right and a freedom to even give a friend, a neighbor, a sister. You can give anybody property or something from through that will. But when you don't have a will, anybody else other than the intended beneficiaries, who are your spouses or your spouse, if you are and children, those are the only people who are going to benefit. And even in their distribution, the choice of how much share they are going to get is going to be determined by the court. And these are the uncertainties that I'm telling you carry now bring chaos because you'll find there's a brother probably who claims, hey, I'm always at home with mom. I'm the one who was always taking care of dad. So I don't know why you guys don't want me to have a bigger share of the estate. Maybe I want a bigger land in this particular town. I want a bigger plot on this particular front. Those are conflicts that at the end of the day now turns a very beautiful family into a chaotic space and a place that can never live happily after. So to avoid those problems, we plan through wills. So to avoid these problems, we plan through estate planning. We ensure that we distribute our estate when we can, when we are alive, when everything is okay. Because without a will, even some of the properties you have may not, people may never know where they are. You went somewhere, you travel you went for a business expo, to a concept in business, you invested some money there, nobody knows where that investment is. You have a portfolio with a particular stock exchange, nobody knows about it. You have properties you bought in Nanyuki, some of the others you bought in Kisumu, others are in Ruiru, and nobody knows where they are. So to avoid those uncertainty, you may find that even in that scales, your family does not fully benefit from the estate because they don't know whether other properties are even out of the country. So to avoid these problems, we encourage our clients to always, and I request our viewers to always plan early, prepare a will, and this will give you a chance to have an inventory of all your assets, have a wish list of how you want all those assets to move to your beneficiaries in case you're not there and a bad thing happen, unfortunately.
Is a will for wealthy people only?
No. Wills, as I told you, carry should be done by anybody, and the best time to do a will is now if you have not done one. And if you have, the best time to review is now. Because we don't know about tomorrow. Anyone who has an asset, who has an estate, let me just use the word estate. Estate meaning you have a plot. That plot you are looking at it like it's just one plot. Can bring chaos in your family for the rest of their lives. It can bring that family into a standstill for the rest of their life. To avoid that problem, have a mechanism of how that plot will be managed where you're not there. That money in the bank may be the source of all the problems in the family when you're not there. When unfortunate things happen in our life, they do, because we live in this world. So to avoid these challenges, let us the will, preparing will, is not for the old. And there is always an African saying that when you plan your estate, it's not a way of wishing yourself to die.
That's why many people fear. Now, another question: can a handwritten will be varied?
Yes, yes, yes. Kerry, they mentioned there are two forms of wills, that is oral and written. So we always encourage clients to have written will. Because document or print document can never change because everybody will be seeing it is written here. This is what they say. This is what they wish. This is how they expressed. Even you can even sometimes people have a chance to even say how they want their remains to be handled after they are gone. So the
What I
handwritten
mean,
wills or
what I mean,
oh sorry,
Wakili,
maybe come again with the question. Maybe I
handwritten.
answer the question.
Okay,
Oh yeah, sorry,
handwritten,
sorry. Oh, you mean
handwritten, not
handwritten?
typed. Can handwritten will be varied?
Yes. Here, when we say written will and unwritten will, or a will, written whether it is typed, whether it is it was handwritten using a pen, it is valid will as long as it was done by an adult of sound mind and in the presence of two witnesses who are independent, and it does not leave out the intended beneficiaries as per the law. So if such will is done, whether it was written using a pen, sometimes people write wills in the hospital, people write wills at home. But even as you do that, let it conform with the law. But typing it makes it better because a typed document is more visible because of spellings, is more the durability in terms of storage to avoid spilling of the ink. So now that boils down to the benefit of a typed and typed document. But written wills, whether it is through a pen or typing, is a valid will.
Okay, you mentioned an executor. Can Can an
Yes.
executor be a beneficiary?
Unfortunately, sometimes they can be, but it's always encouraged they should not be, because executor is majorly someone who is an accounting officer. Your work is to account, to bring, first of all, to bring together the properties, or to bring together the properties, to know where they are. If someone had some properties, maybe in Machakos, we had some lands, some investments in Mombasa, we had some investments in other towns, Nakuru, they ensure they consolidate them. They are the accounting officer. Their work is to bring those documents, those properties together. If there are court cases against your properties, to ensure they are handled. Then they manage, if there is rent collection, they collect the rent and ensure those proceeds are kept safely, and then help implement what the will says. Ensure that if they are filing the probate in court, they attach the correct will and distribute the estate in the right manner. So that person can be one of the beneficiaries, because sometimes it can be the eldest child, or maybe one of the child or one of the family members who is you have given that responsibility. Or sometimes you can even hire your lawyers to do that, or an independent person, a friend. As I told you, you can even get a friend to be a decision. The same way, even in the intestate or where there is no will, there is administrator. This administrator is not a must they be family members, but most of the time you put family members for purposes of ensuring family interest are safeguarded. So they always need to remember that the administrator and executor, their role is to do something we call bringing, administering, managing the estate and ensuring it is properly distributed and accounting for it. So they are more or less CEOs. So someone can only benefit by being paid an allowance, but not inheriting more. They cannot inherit more and demand that because I'm the one who became an administrator, I should have more share, I should have more land, I should have more money. No, they can only be, if there is any remuneration, is in form of money or allowances.
Okay, is a spouse automatically entitled to all property after the death of a spouse?
No, no, a spouse has something we call a life interest. A wife, let me say, a wife has a life interest on the estate of the husband. And this life interest means for as long as they remain unmarried, for as long as they don't get married, the properties, the house, where they were living, the household, there's a category of the items that are absolutely theirs, and also they have a life interest on the rest of the properties. So you cannot disinherit where you find a family, they are going to a court and appear or telling their lawyers that you have distributed all the properties and all the land, and one of the child is going to be hosting your mother in their houses, so they're not going to provide for them. The law has provided a life interest on such a spouse on the estate as long as they remain unmarried. The moment they get married, they lose that interest, and automatically that interest passes to the children, because all the property that is left to a spouse is meant to be held in trust of the children. So if a father dies today, all that property is left on the interest of the children and is only held by the mother as a trustee.
Okay, what is the single most
That
important
is why
document?
this is why Kerry, you find, sorry about that, you find even when people are doing succession where there is no will, children who are adults will be requested to sign a consent even if their mother is there, because at that time both the children and the mother have equal rights over the properties. That's why they sign the consent.
Okay, what is that single document,
Yes.
single most important document, estate planning document everyone should have?
The most important one is will, because having a will is one of the most secure way of planning your estate. Apart from the other things that you may have, maybe trust and all that, having a will ensures that all the properties and how you want them distributed has been done. And all your wishes on how you like things to be managed after you're gone is put in writing. So, with the only most secure document of planning your estate. And don't wait for the future. Do it now, do it early. Take.
Okay, what final message would you like to give to families uh, regarding succession planning, inheritance, and preserving wealth for future generations?
One thing I would like to tell us is that our brothers and sisters, I know they have worked very hard and they're working very hard to secure a legacy for their loved ones. It is so sad that that future of their loved ones go wasted or become uncertain. And therefore, to avoid those problems, we encourage them to plan their estate, start planning now, wait for them, so that that uncertainty befall your loved ones. But instead, apart from building the legacy, you'll have built something greater, handing over a successful legacy. So let's do this right and ensure that we secure the legacy of our children. And as our firm, we are always ready to assist in ensuring that is done.
Okay, now you can give us your parting shot, give us your contact, tell our viewers and listeners how they can reach you, even as we come to the close of our show.
I'd like to remind our listeners and our viewers that the cost of planning is always lower or cheaper than the cost of that is brought to a family dispute or the cost of family disputes. Because those family disputes breaks the families to the core. So let's plan our estate. You can reach us through our website. We have our website that is www.asbogwalaw.co.ke, or you can reach us through WhatsApp. That is +254 799 7 sorry 0797 445 031. +254 797 445 031. Or even our email, that is info@asbogwalaw.co.ke. So we are very much ready to assist and to guide every step of the way so that you can ensure you secure and protect that legacy and avoid the costly family disputes.
Okay, thanks so much, Advocate Steve Mbugua, for sharing
Thank you very
with
much, Ken.
us your expertise on succession and estate planning. We hope this discussion will help our viewers and listeners to protect their families, preserve their wealth, and avoid unnecessary legal disputes. To our
Thank you very
viewers and
much.
listeners, this is Kerry Prestige coming live from Seattle, Washington. Until next time, when we will host our resident advocate, Roya Steve Mbugua.
Thank you.
Shalom, shalom,
Thank you
shalom.
very much. Shalom.